All right, so I wanted to come back. Um, Today is Sunday, July 9th, 2023. And I did a couple of TikToks earlier this morning about an opinion piece that was in this morning's New York Times, written by a woman named Linda Greenhouse. Linda Greenhouse is a badass. She reported on the Supreme Court for the New York Times from 1978 until 2008. And in 1998, she won a Pulitzer Prize for some of that work. She's been an opinion columnist for the Times from 2009 until 2021 when she retired. But she wanted to write this piece about the last term of the Supreme Court, and it is excellent. Her name is Linda Greenhouse, New York Times. The title of her article is "Look at What John Roberts and His Court Have Wrought Over 18 Years." And it's a really good article, and I recommend that everybody go and read it. But I wanted to come back and spend some more time on it than I can in a 3-minute long TikTok. So I'm putting this one up on my YouTube page, and I'll post a clip of this on my TikTok. There's a link in the bio. Click on the thing on my profile photo. It'll take you to my profile. There's only one link in my link tree, and it'll take you to my YouTube page. And she starts off by saying, questioning this court and basically saying, did they really redeem themselves in their decision in Moore versus Harper, where they rejected the independent state legislature thing that, basically protected just basic democracy and voting in the United States? And she kind of argues, yeah, not so much. Not really, not so much. And she starts off by offering kind of a thought experiment. And for context, John Roberts, the current Chief Justice, has been Chief Justice for 18 years. He became Chief Justice in 2005, shortly after the death of then Chief Justice William Rehnquist. Roberts was elevated to Chief Justice by George W. Bush. Here's her thought experiment. Suppose a modern Rip Van Winkle went to sleep in September 2005 and didn't wake up until last week, the end of June. Such a person would awaken in a profoundly different constitutional world, a world transformed term by term and case by case at this Supreme Court's hand, largely. And consider in that context what the conservative wish list was for the Supreme Court back in 2005. Overturn Roe versus Wade, reinterpret and expand the Second Amendment as it relates to private gun ownership and making that a constitutional right. Eliminate race-based affirmative action in university admissions, elevate the place of religion across the legal landscape, and curb the regulatory power of federal agencies. Agencies like the EPA, the Department of Energy, the Department of Education, all the cabinet positions in a presidency. And that's not even including other things that this court did do and that Chief Roberts did do relative to the Voting Rights Act, relative to what they just did with student loans, relative to LGBTQ rights, what they just did last week. The LGBTQ community, as far as the Supreme Court concerned, didn't have any rights in 2005 when Chief Justice Roberts took over. The Obergefell case legalizing gay marriage came several years after that. We'll talk about that in a minute. So it's like conservatives largely viewed the Rehnquist court, the court that existed during the time that Rehnquist was Chief Justice, as a failure because it hadn't accomplished any of these goals. In 1992, the Rehnquist court reaffirmed abortion in Casey versus Planned Parenthood. In 2000, that same court overturned a state law banning partial birth abortion. And on gun rights, and bear in mind this on gun rights, prior to the Roberts Court, the United States Supreme Court has never recognized an individual right, a private individual's constitutional right to own a firearm outside of the context of them being a part of a militia. Because that's what the Second Amendment says, a well-regulated militia. This is the first few words of the amendment. We'll come back to that too. And the Rehnquist court, just maintained a decades-long silence on that constitutional right, much to the chagrin of conservatives in the NRA. And in one opinion, in a dissent, I think it was, in 1997, Clarence Thomas, just lost his shit. And he was like, this is wrong. We need to expand this. And in 2003, there was a decision in a case called Grutter, Gutter, which upheld and affirmed affirmative action in college admissions relative to the University of Michigan's law school. And these things were settled law, precedent, in place, bedrock stuff, settled law, precedent. The Roberts Court was like, hold my beer. And on religion, in a 1990 decision written by fucking Antonin Scalia, of all people, held that the First Amendment's free exercise clause ordinarily did not provide a religious opt-out from compliance with laws that applied to everyone else. That's exactly the opposite of what the court held last week in the 303 graphics web design case. We'll come back to that. And in one of the last opinions that was written by Chief Justice Rehnquist in a case called Locke v. Davey, it rejected the claim that offering scholarships for post-secondary education required that study for the ministry be paid for as well. And that case would have been decided in a completely different manner today. And finally, as it relates to the actions of federal agencies, specifically the EPA, they've always had a problem with the EPA. There was a 1984 case called Chevron, which basically set the standard that as long as federal agencies, the administrative state, which everybody on the right likes to refer to as the deep state, follows just a basic set of guidelines in arriving at decisions internally when they are forming and drafting regulations, which then they impose on other people out in the general public. As long as the agency acted reasonably and went through certain steps, the Chevron case said that the courts are required to show deference to those agencies in making those decisions and writing and imposing and enforcing those regulations. It's just called Chevron deference. And that's out the window. It hasn't been explicitly overruled, but it has been effectively overruled, as has the Grutter case when it comes to affirmative action. We'll talk about that in a second. So that's what the court looked like in September of 2005. That's what the conservative wish list looked like in September of 2005 when John Roberts took over as Chief Justice. So let's talk about John Roberts for a second. John Roberts is an institutionalist. What does that mean? He cares deeply about the institution that is the United States Supreme Court. He cares about its respect. He cares about the court being taken seriously. He cares about the history and the legacy of the court. And I think one of the best examples of speaking about John Roberts and legacy and the court and its history and its importance in American history and in American society is all the times that conservatives have challenged Obamacare during his, I don't even know what the term is, Chief Justiceness, during his reign, during his time in office as Chief Justice. He was like, no, my legacy and the legacy of my court when I'm the Chief Justice is not going to be overturning Obamacare. My legacy is not going to be throwing out this piece of landmark legislation that was arrived at properly, democratically, legally, and within the bounds of the Constitution. And when he came down on the wrong side of a couple of those decisions, conservatives across this country lost their mud, man. I mean, they lashed out at him like you can't even imagine. They said he was a traitor. They called him every name in the book that you can think of. He's like, you're not doing this to the court on my watch. And again, in 2023 and 2022, the other conservatives on the court were like, hold my beer. Yeah, because that legacy is toast. It's done. The John Roberts Court is going to be known as the most corrupt Supreme Court in modern history, with all of their financial bullshit that every single conservative on that court is dealing with and has in their past. And it's going to be known as the only court in our lifetimes who does not give a shit about precedent, period. This court and these conservatives are chucking precedent left and right, all over the place. And speaking of precedents, it's like in 2005, let's think about the things that were precedent. Let's think about the things that were settled law. Roe versus Wade, which had been reaffirmed in Casey versus Planned Parenthood. It had been reaffirmed as precedent in a Supreme Court case. And affirmative action in the Grutter case in 2003, affirmed and reaffirmed as precedent. But even Justice Thomas in the decision that came out last week, doing away with precedent on affirmative action, Justice Thomas was certainly correct in his concurring opinion when he wrote that it was, quote, clear that Grutter is, for all intents and purposes, overruled, even though it was not specifically overruled by the court. Likewise with the Chevron deference decision as it relates to federal agencies. And I think the EPA case that was just before them had to do with waterways and marshes and how those are regulated and what's connected waterways-wise and what's not connected. And it gutted the EPA's ability to regulate marshes, swamps, waterways, things like that. And replaced Chevron deference with what's called the major questions doctrine. And under this doctrine, the court will uphold an agency's regulatory action on a major question only if Congress's original grant of authority to the agency, the statutory language that created the agency, on this particular issue was explicit. And she sums it up nicely in her last sentence in that paragraph. Deference, in other words, to a federal agency is now the exception. It is not the rule. Because, Department of Education, the EPA, the Department of Energy, the Department of Commerce, the Department of Labor, OSHA, they put out regulations all the time. And for 40 years, the precedent at the Supreme Court has been, if that agency acted reasonably and took certain steps in, researching that issue and constructing this regulation and putting it out and requiring people to be bound by it and enforcing that regulation, if they had acted reasonably throughout that process, then the courts are required to defer to that agency as it relates to that specific regulation. Now, the court, even though it did not specifically overrule the Chevron case, completely changed the standard to the point where the Chevron case is now meaningless. Saying if a federal agency is going to put out a specific regulation, the only authority they have to do that is if in the statutory language that Congress wrote authorizing the creation of that agency included that specific authority to create that specific regulation, then that regulation's out. It is going to gut the ability of essentially any federal agency to regulate just about goddamn near anything. And what did Steve Bannon say repeatedly and famously when Donald Trump got elected? He wants to destroy the administrative state. This court has just gone a long way to doing that. You want clean water? Sorry. Clean air? Maybe next week. You want your kids to get a good education? Head Start, free school lunch, after school programs? It's not in statute. Sorry. That's where we're going. And here's the best part. Justice Neil Gorsuch was candid about this in a concurring opinion last year when the court limited the Environmental Protection Agency's ability to regulate emissions from power plants. The major questions doctrine, he explained, quote, applies when an agency claims the power to resolve a matter of great political significance. What is a better indicator of political significance than sustained conservative backlash over 30, 40, or 50 years? And that decision set the stage and the basis, in part, for the court's decision last week to throw out Joe Biden's student loan program. Now, here's a really important thing to know about Justice Neil Gorsuch, who currently serves on the United States Supreme Court. Under Ronald Reagan, his mother was appointed to run and be the head of the Environmental Protection Agency for the purpose of dismantling it. And she went too far, too fast in those tasks and found herself in a situation where she was being essentially offered a deal by the Department of Justice, resign or we're going to prosecute you. And so she resigned in disgrace. That deeply wounded now Associate Justice Neil Gorsuch, who sits on the United States Supreme Court. He has wanted revenge for that for the last 40 years. And now he gets it. Let's talk about guns. The 2008 decision of Heller versus Washington, D.C. It was Washington, D.C. had a complete ban on the ownership of handguns in Washington, D.C. And that was in an opinion written by Justice Antonin Scalia. It was the first time, 2008. This country was founded in 1776. 2008 was the very first time that the United States Supreme Court determined that there was a constitutional right for individuals, private individuals who were not part of a militia, to own a firearm to keep in their home for self-defense. That was that case. Well, how did Roberts Court go further with that? In the 2022 case, the Bruen decision, B-R-U-E-N, it had to do with concealed carry permit requirements being different in different states, and different states having different standards. And states that had more restrictive standards that imposed a heightened requirement on the applicant to show that they needed to have a permit to carry a gun above and beyond, just garden variety self-defense. The court threw that out. And it was a breathtakingly broad opinion. I'm reading from the article, rejecting any limitation on gun ownership that can't be tied to an analogous limitation on gun ownership in the 18th century. That's the standard that today's court in 2022 last year used in determining concealed carry permit application requirements. What would have been required in the 18th century? I laugh because if I don't, I'm just going to lose it. And here's the kicker. So the court threw out every state statute that had those heightened requirements. You have to show a heightened requirement above and beyond garden variety self-defense. You have to show that you are the target of a particularized threat in order to be able to carry a concealed permit or concealed carry a handgun. We had that statutory structure out here in California. I live in San Francisco, and it's in rural counties in California, you can get a permit to carry a gun all fucking day long, man. In San Francisco, they had not issued one in over 30 years, or less than 3 or 4. I think the last person who had gotten a concealed carry permit in San Francisco was Dianne Feinstein after the murder of Mayor Moscone in like 1978 and Harvey Milk. Well, now San Francisco is issuing carry permits again because of that concealed carry case, the Bruen case that the court decided last year. Being a gun owner, I have mixed emotions about that case, and I have mixed emotions about the fact that San Francisco is issuing carry permits. I don't know whether or not I'm going to get my carry permit yet. I'm leaning towards yes, but we'll see what happens. We'll see what happens. The kicker is that because the court said they expanded on the Heller decision to say, well, individuals don't just have a constitutional right to own a firearm to keep in their home for self-defense. They have a constitutional right to carry a firearm out in public also for self-defense. And along that theory, the court accepted another case that they're going to hear in their next term. On June 30th this year, the last day of the term, was also the last day of Pride when they issued their 303 web design case, which we'll talk about in a second, finding a constitutional right for private businesses to discriminate against gay people. Reading from the article, on June 30th, the court agreed to hear United States versus Rahimi, which will put the Bruen approach to the test. The question in that case is whether the Second Amendment allows the government to bar gun ownership, to prevent gun ownership by an individual under a restraining order for domestic violence. That the answer to this question might actually be no. Domestic violence wasn't even a concept in the 18th century when the Second Amendment was adopted, is too astonishing to contemplate. Because the court set the standard in Bruen that you can't restrict individual private gun ownership in a manner that's inconsistent with any legislative structure doing the same thing in the late 1700s. You think there was a lot of awareness of domestic violence in the late 1700s? The number one cause of death of pregnant women in the United States today is homicide by their partners. Thousands of women in the United States are murdered every year by their partners. I'm going to tell a couple of personal stories here. When I first started practicing law, I graduated from law school at the end of 1998. And I started practicing after I passed the February bar exam in 1999. I was practicing in rural Ohio. I was working for my mom. And she did exclusively family law, domestic stuff, divorces, custody, restraining orders, things like that. Over a 2.5-year period, we had 3 clients, all of whom were women, all of whom were murdered by their husbands who they were divorcing, all 3 of whom had restraining orders against their husband. In one of those cases, we filed for divorce. We got the husband served. There was a lot of domestic violence in the case. They were both prison guards. And we got a restraining order against him. He had to give up all of his firearms and he had to move out of the house. They had 5 children under the age of 10. He borrowed a 9mm handgun from a buddy of his who was a sheriff's deputy. And he waited on the side of the house one day for her to come home from picking their 5 kids up from daycare and from elementary school. And as they all piled out of the minivan, he came running around the corner and shot her to death in front of the kids. And then he put the barrel of that handgun in his mouth and blew out the back of his own head. Another one of our clients, her husband was a psycho. He came into her house one day when she was at work. He turned off the breakers so it would appear that the power was out. And he disconnected the gas line from the back of the stove so it filled the entire house with gas. She came home and lit a candle, blew up the house and killed her. That this United States Supreme Court, after last year overturning Roe versus Wade and taking away every woman's right to an abortion, is now going to expand gun ownership to include people who have domestic violence restraining orders against them, is disgusting. It is absolutely disgusting. And then we get to the subject of religion. In the case of the web designer, and she writes a couple of things here that I really appreciate. I was baffled when the court agreed to hear the designer's appeal in February of last year, and not only because the designer, Lori Smith, had not yet designed a wedding website for a paying customer, and she had not turned anyone away, indications that the case was not ripe for review, meaning that she didn't have standing to bring a case, and that there was no case in controversy. And so from what I've read, apparently she brought what's called a motion for declarative relief, a motion for dec relief. Basically, it allows you to sort of, at the state court level, bring kind of a hypothetical question to a court so that they can resolve it for you. But there is no earthly reason why the United States Supreme Court should have taken up this case where there's this woman on one side saying, well, what if I have to do X, Y, and Z, even though I've never had to do it and nobody has asked me to do X, Y, and Z? They never, ever, ever should have taken this case. Whatever. But her attorneys kind of put forth the case with two questions. There's a freedom of speech question and a freedom of religion question. And in the First Amendment, what's in between those? That's right. That's right. The wall between church and state. Yes, exactly. The Supreme Court only agreed to hear the case on the free speech question because they didn't want to bring religion into it, because they didn't want it to be about religion or freedom of religion. And what do I always say in my TikToks? When you hear a conservative say freedom of religion, they're always leaving off the two most important words. Freedom of religion to discriminate. That's what they're saying when they say freedom of religion. I should be free to discriminate against members of the LGBTQ community because it's against my religion. My religious beliefs, I should have the freedom to impose those on other people who do not share those beliefs, and I should be permitted constitutionally to discriminate against those people and punish them and not afford them the same rights and freedoms that every other person in our society has. Freedom of religion means freedom of religion to discriminate, period. Just is what it is. And again, Gorsuch wrote the majority opinion on this in this case as well. And the crazy thing is, apart from the hypothetical nature, the fact that the man that she named in her pleadings and provided an email address for him has been married to a woman for years, is not gay, and never contacted her for anything, which I still can't process. That aside, this court, in this hypothetical case, created a religious opt-out from compliance with state and local laws that govern the commercial marketplace. And I think that, and Gorsuch cited a whole bunch of analogous cases and all that stuff, but none of those precedents that he cited are relevant because none involved discrimination by a commercial entity. They were all by non-commercial or religious entities. And Elena Kagan wrote the dissent in this case, and it included a sentence which I thought was just absolutely brilliant and equally terrifying in what it tells us about this court today. She wrote, "Today, the court, for the first time in its history, grants a business open to the public a constitutional right to refuse to serve members of a protected class." I mean, that sentence stopped me in my fucking tracks, man. It just did. It just stopped me in my tracks. Today, the court, for the first time in its history, grants a business open to the public a constitutional right to refuse to serve members of a protected class. And the court couched it in terms of the First Amendment free speech. They couched it in terms of free speech, not freedom of religion. They said that this business owner, if they were forced to create this website for a gay couple, that is compelled speech. That is compelled speech. So these people aren't stupid. They're coming up with these kind of workarounds for things. And if you read these opinions, the amazing thing about a lot of these opinions, they are completely fucking rewriting American history, man. I mean, you read some of the history that's in that affirmative action case, it's like, what fucking country are you guys living in? They just rewrite history entirely. And, you know, I'm just going to read this next paragraph from the article because I think it's important. A full understanding of this case 303 Creative versus Elenis requires context. It is now 8 years since the court in Obergefell v. Hodges recognized a constitutional right to same-sex marriage. Of the 6 members in the majority in the 303 Creative case, 3 were on the court at the time the Obergefell case was decided, and all 3 of those justices, Chief Justice Roberts, Clarence Thomas, and Samuel Alito, were in the dissent on the Obergefell case. Justice Alito's dissenting opinion, which Justice Thomas joined, was bitter. The decision would be, quote, used to vilify Americans who were unwilling to assent to the new orthodoxy, unquote, he warned, meaning recognizing that gay people exist and they should be able to get married. Roberts, Thomas, and Alito were very, very angry about that. How sad. How sad and pathetic as a human being do you have to be? Man, reading on. Since then, those 2 justices, Thomas and Alito, have been searching for an Obergefell victim whose plight would vindicate their expressed concern. It wasn't easy, but finally, despite the appeal's obvious procedural flaws, there's no defendant. They made him up. In the 303 Creative case, they found one. They've been hunting and waiting for this case. And they've been depending on organizations like the Federalist Society and the Alliance Defending Freedom, a hard-right Christian litigation group, to find a case like this at the state court level and run it up the chain and bring it to the Supreme Court so that they could issue the decision that they did. Today, the court, for the first time in its history, grants a business open to the public a constitutional right to refuse to serve members of a protected class, the LGBTQ community. You think for 2 seconds that this isn't going to affect every other protected class? After the affirmative action case, there are conservative groups now that are coming after minority scholarships. You don't think after the 303 case that there are going to be conservative groups, we should be able to discriminate against people who are Jewish, who are Hindu, who are Muslim, who are from foreign countries, who are old, who are women, who are pregnant, who are different nationalities. A constitutional right to refuse service to members of a protected class. There are a lot of protected classes, and this is not going to stop with the LGBTQ community. The Supreme Court now is the country's ultimate political prize. That may not be apparent on a day-to-day or even a term-by-term basis, but from the perspective of the past 18 years, that conclusion is unavoidable as it is frightening. This court, today's GOP, are hell-bent to take us back to 1957. And who had rights in 1957? White Christian men, straight white Christian men, cisgendered. That's what they want. That's the society that they want, along with an authoritarian theocratic leader. And this court is going to help them do it. I didn't have fighting this stuff on my bingo card for my mid-50s into my 60s. I'm 55 years old. I didn't have fighting theocracy, fighting authoritarianism, fighting fascism, fighting against little meatball McPudding fingers like Ron DeSantis on my frickin' bingo card for when I'm supposed to be looking forward to retirement. This court is illegitimate. It is atrocious. I don't know what the answer is, apart from voting and voting and voting and voting and voting and voting. And that may not even be enough, because Republicans cheat. It's the only way they can win. So at 9:40 p.m. on a Sunday, as we're all getting ready to go to work tomorrow, I know I've got like an hour and a half worth of prep stuff I got to do before I start work in the morning. I hope everybody has a good week, a good Monday, and don't let the bastards get you down. Take care.